Dobre, może...
I believe we can start. Esteemed ladies and gentlemen, on behalf of the Center of Legal Studies, I would like to welcome you here. And this is the first event organized by our center in Kiev, but I can tell you that that's not the last one. Tomorrow we will have similar expert discussion on dual citizenship. I will be speaking in English because English is the language of this event. I also would like to say that I'm happy. Yesterday we were celebrating the Day of the Constitution of Ukraine, and today we'll be talking about very important issue, one of the fragments of the reform of judiciary in Ukraine. That's the novelty of the code of administrative code in Ukraine.
I'd like to welcome you at this very event that marks the launch of a series of similar events organized by the Center for Promotion of Polish Legal Research here in Kiev. I'm very glad to have you here, and I'm very glad because yesterday there was the Day of Constitution here in Ukraine. The whole country celebrated. And today we're gonna discuss a very current topic of reform in administrative judiciary, especially the amendments made to the Code of Administrative Court Procedure. And I would like to welcome guests that are with us today. Mr. Mykhailo Smokovych, Суддя Wyższego Administratywnego Sudu. I switched the language. The judge at the High Administrative Court of Ukraine, the Secretary of Plenum. Please welcome. Professor Marek Wierzbowski, a partner at Wierzbowski Partners and head of scientific council at the Institute of Administrative Law at the Faculty of Law and Administration of University of Warsaw. I would like to welcome Professor Piotr Przybysz, judge at the Voivodeship Administrative Court in Warsaw and professor at the Faculty of Law and Administration of the University of Warsaw. I would like to welcome Mr. Roman Kuybida, an expert of the Center for Policy and Legal Reform, the vice chairman of the board of this institution, and Mr. Mykhailo Jabłoński, PhD, head of Department of Administrative Law at Dentons Warszawa, and also graduate of our faculty. We are still awaiting our sixth guest, Mr. Viktor Korolenko from the administration of President of Ukraine. I think he will be with us in 10-15 minutes. But let's start to discuss this very current topic. I would like to start with Mr. Professor Piotr Przybysz. I would like to ask you to tell the Ukrainian audience how the system of administrative judiciary looks in Poland. We know that there are many differences between Polish and Ukrainian system, and please tell our guests how the system looks in Poland and what is from the point of view of a judge, because you're an active judge at the Voivodeship court. What are the strong and weak points of the system?
Thank you, Mr. Chairman. Ladies and gentlemen, I will start with some general, very introductory remarks concerning judicial review of public administration in Poland. And I think that the most important thing is that the administrative court are a form, the most important form of civic control over public administration. This is the reason of existence of administrative courts. People are laïcs. They don't know much about administrative law, but they can feel that something is wrong with public administration. And then they start proceedings before the administrative court. Anyone can start it. And administrative judges are professionals. They will do the rest. And they will verify if everything is okay with contested action of public administration. The second important thing about Polish administrative judiciary, there is no organizational or jurisdictional connections between administrative courts and civic courts and Supreme Court. Administrative courts are independent branch of the judiciary. There are two instances of administrative courts. The higher court, the Supreme Administrative Court, and 16 Voivodeship administrative courts. Another very important thing, some administrative cases are examined in civil courts. So, administrative courts deal with only very, very wide cases, very different cases, but not all the public cases. Any person who graduated from Faculty of Law and possesses a significant experience of work in public administration, or someone who knows very well public administrative law, might be an administrative judge. So it's not a post only for professional judges. Well, and now I will go to some ideas, some basic ideas of judicial control of public administration in Poland. It is a control initiated by private persons. Only private persons can initiate the proceedings before the administrative court. Of course, it must be a person who possesses a legal interest in case. So it might be, in other words, someone who received a decision, administrative decision. It cannot be anyone, but only the person who is interested in reviewing legality of public administration activities. Another very important feature of Polish administrative control system is prohibition of reformationis in peius in Latin. It means that the claimant cannot worsen his or her situation because of his claim to the administrative court. There are also some special situations when the court might worsen his or her situation, but as a principle, people should not be afraid of putting claims to the administrative court. The next very important feature, only legality is the criterion for reviewing the activities of public administration. Nothing else, only legality. And the legality at the moment of making a decision. Not before, not after, but just at that moment. Administrative courts in Poland don't administrate. They just review administrative decisions and they can annul the decision that infringes the law. The court cannot make a decision. It's just a principle that the administration administers and takes responsibility for administering, for its activities, and court make justice. Proceedings before the administrative court. Claimant does not pay for losing the case in the first instance. The court fees are quite low. For instance, the usual fee is 100 Polish zloty. It makes about 25 euro. There is also a proportional fee, maximum 120,000 zloty. It makes about 30,000 euro. In some cases, claimants don't have to pay because the state budget pays for them. The problem of excessive use of rights by claimant. It's a problem discussed recently in Poland, and some people say that we should not say that the people, private persons, could use their rights in excessive way, because it's a consequence of the statute that allows them to do so. And others say that it might be seen sometimes that people don't want to seek a legitimate aim by putting the claim to the court. So it's quite difficult to say in a general way whether it is possible to use the rights in excessive way. But I should say that the court have possibilities to react in a different way to different situations. Cases are decided on a principle first came, first decided. It's very important and it's very natural. There are panels of 3 judges, and they are hearing the case at trial, at open session. It's the usual way of dealing with cases. But there is a possibility to examine cases in closed session. It's a simplified procedure. Simplified procedure is trendy recently, became trendy recently. Why? Because it's not time-consuming. 3 judges gather, discuss the case, prepare the judgment, and that's all. And the open session is time consuming because there is 30 minutes, usually 30 minutes, for every case. 3 judges, 4 cases. It means we are working 1 day a week at the open session from 9 a.m. to 4 p.m. Sometimes we finish later, sometimes earlier. Simplified procedure is quite simplified. It means that the only difference between the simplified procedure and the normal procedure is that the judges are reviewing the case on the closed session, and that's all. The rest is the same. There is also interesting regulation concerning cases that might be reviewed in simplified procedure. It's connected with a simplified procedure before administrative bodies. But simplified procedure before administrative bodies is something new. It was introduced recently, just 1 month before, since 1st of June this year. It's really a very simplified procedure because it's initiated by a person interested whom is using a form, just fills in the form, indicates the evidence, formulates only one demand, and that's all. And the administrative body has 1 month to verify the case and to make a decision. So it's really very, very simple procedure. Mediation, another hot topic recently. Mediation in administrative courts was introduced in 2004. It was very trendy at the beginning, but now it's a dead institution. Why? Some people say that claimants prefer to get a judgment instead of consensus, an agreement after the mediation. The time of getting the judgment is similar to time of reaching the consensus in mediation. Sometimes people just prefer to get a judgment because they see it as a solid. Another reason for failing of mediation is that the mediation was conducted by judges or court clerks. And judges and court clerks are not prepared to conduct mediation. Simply, they are not trained to mediate, they are trained to make judgments. And this year there is a very important change in mediation before courts, administrative courts, because the new regulation provides that the mediation should be conducted by mediators, persons who are prepared to mediate in different proceedings, in administrative proceedings, in civil proceedings, and so on. So some people say that it would change dramatically the situation with mediation, But I think that there should be no changes. Why? Because mediation is an alternative to a judgment. And I think that mediation should be an alternative to the claim to the court. And I think that it's the most important and the most interesting for Ukrainian. Thank you.
Thank you very much, Professor. I wanted to ask you about the new regulations that have been introduced in Poland in recent years, but actually you mentioned, I think, most of them. I think that many of the topics you told us about, like mediation and simplified procedure, are very interesting for our Ukrainian colleagues because they are included in the new bill that was passed by the Rada in the first reading. And I hope that in the discussion we will be able to find the pros and cons of this solution. Thank you very much. Now I would like to move to Judge Mykhailo Smokovych. Judge, could you attempt to present the system of administrative judiciary in Ukraine and maybe to compare the system in our countries? We know that the history of administrative judiciary in Ukraine is not very long, and please, if you can share opinion, why the amendments of the code are needed right now. And I would also like to use this opportunity to welcome Mr. Viktor Korolenko from the Administration of President, Department of Representation of the President of Ukraine in the courts, that is one of the authors of the project. Please, Mr. Judge.
Thank you. Good afternoon, everyone. To all, good afternoon. We are glad that we have such events, and we are glad that our Polish counterparts were invited. They have this established administrative justice, and I would like to say that administrative courts of Ukraine, they learned a lot from their Polish colleagues. And concerning administrative justice in Ukraine, High Administrative Court as a cassation, it was created by the President of Ukraine in 1992. This court was created in 2002, so 15 years ago. And the district courts were created as of 16th of April of 2004. So in this way, these administrative courts were created. And then the Code of Administrative Justice was made on the 6th of June 2007 and 2005, and the administrative courts, local administrative courts, are also the courts of general jurisdiction, and this is connected with the fact that before they reviewed the lists of voters and the politicians that were in the parliament, people's deputies, they understood at that time that we should have reviewed these lists, and a lot of voters addressed to courts, and district courts, they were in the oblast centers, and if the voter in the day of the elections got information that he is not on the list of voters, and he should address with the appropriate claim in order to verify his name in the list, and they should have gone to the regional centers, and they are in, for example, 250 kilometers away. So in this case, the parliament made a step in order that these cases were reviewed by courts of general jurisdictions as in administrative courts, and also they reviewed the cases. For example, the decisions on the bodies concerning bodies of power and bringing persons to administrative liability. So from the start, we had such local courts, district courts in every region, in every regional center, local general courts in each administrative center, where they had courts of general jurisdictions that played the role of these administrative courts. And at that time, they also created 7 courts of appeal in administrative cases, and also created 2 courts in Vinnytsky and Zhytomyrsky Court of Appeal. And also, we have now 9 courts of appeal, 8 are in operation, and about Sevastopol Court of Appeal, it is not in operation because of occupation of Crimea, and the Court of Cassation is the Supreme Court of Ukraine. So this is the system that was established concerning administrative courts. Also, according to the law, and also the chamber on reviewing administrative cases was made at the Supreme Court in order to review decisions if the material laws are applied in different ways by different courts. So, and also to provide the cases to the European Court of ECHR. So if there were cases of human rights violations, and then this case could be reviewed in Ukraine as well. So this is concerning the system and about the judiciary. So the Supreme Court started its work on the 1st of September 2005, and other courts, their functions were implemented by the courts of general jurisdiction, economic courts, and also courts of appeal, the courts of appeal and economic courts of appeal. It was before the special administrative courts were established. So this was the start of this reform 12 years ago. Concerning the problems, the biggest problem while starting judiciary in Ukraine was the establishment of jurisdiction of administrative courts. So to identify whether this dispute is of administrative nature, that was the biggest problem. And according to legislation, the highest court was provided from high economic with cases from high economic court, more than 10,000, and they were provided from also from civil chamber. These are public cases that were provided from there. So, and 27 judges started to work at high court, and more than 30,000 cases where they started to work with 30,000 cases, and jurisdiction of administrative court was identified clearly in the Code of Administrative Judiciary, and also there was high economic court and civil chamber to review civil cases at the Supreme Court of Ukraine. So they provided cases to us, and we established criteria according to which we identified the cases of administrative jurisdiction. And for 1.5 years, it was really good. These criteria were being established, and a lot of scientists were expressing their opinion in their scientific works, and also scientists started to they also defended dissertations on these matters, and they established jurisdiction, and it was established by law. And second, we should do it in relation of the character and of these relations. So this should be public. So the jurisdiction should be established. Also in separate cases, these courts can review this public disputes. And also the High Economic Court practice changed, and then they started to identify the jurisdiction was made not on the subject, but on the subject, and some confusion appeared, and 3 times Constitutional Court expressed its opinion. First, it provided its opinion on land disputes, and on the 1st of April 29, they took a decision in which they said that this decision of local government concerning the issues of provision to land for use or for ownership or for lease, so this is in the jurisdiction of administrative courts. And despite this, the Supreme Court didn't take this decision. They didn't take it, and when there is a decision of the Constitutional Court on which we should clearly define the jurisdiction, and it should be implemented in Ukraine by everyone, the Supreme Court came out of this position, and they said that despite this decision can be appealed on this land plot allocation or provision to the lease, but if this is concerning the dispute on the land ownership, so this is the civil jurisdiction or economic jurisdiction, not administrative jurisdiction. So as of today, I would like to say that this issue still remains unresolved, and jurisdiction will be identified by the subject, but concerning land as the object of dispute. So here, if the dispute is between private persons, this will be private matter, and if it is in the public sphere, so taking out land for public purposes, so this will be public matter, and if it is between economic entities, this will be an economic dispute. So one subject is not enough to identify whether it is an administrative judiciary. So we should understand the character of relation in which this dispute arose. So after creation of the system of administrative courts, there appeared a problem concerning the judges of these courts. So the disputes with the power, these are not pleasant disputes for judges. These are difficult disputes and concerning the responsibility and legal regulation, and also identification of matters. So all the courts at that time, they depended on the bodies of power in all relations, in their material and financial support, and the financial support and housing, provision of housing to judges, That's why the main strike administrative courts, they relied more on young people who were really professional. They wished to work at administrative courts. And as of today, we are really glad because due to these young people, administrative justice in Ukraine, except separate cases, it is really at the high level concerning the use of modern legal technologies, including practices of the European Court of Justice and the supremacy of law. So I believe that administrative courts are really high in this respect. And we compare our situation with the situation in other countries, and the supremacy of law is in the Acts of 2005, but first they started to realize this principle, and it is also incorporated in public code since 1963. If you open the article of this code, we may see such words that the court verifies whether the state body or local government body took decision in the framework of law and didn't violate the rights and interests of the citizens. So it's not, and it was stated that it is not enough just to verify whether this governmental body acts according to the law, just to verify the adherence of the norm, but also that maybe whether they violated the freedoms and rights of people. So it was provided in legislation before, but we should have implemented it. And today we have it. And thanks to the decision of the European Court, we start to defend the rights of people concerning convention provisions and the decisions of the European Court on Human Rights. And also we have some drawbacks, and I heard from my colleagues from Poland that we have some problems, and in Poland only physical and legal entities address these courts. And we have such a legal system that also the governmental bodies address here in Ukraine. This regulation was made in 1992, 1995, and this regulation was provided by law, and the Supreme Council made the step. And the Supreme Council saw that the controlling bodies the verification, the control, it is difficult to rely in these matters on state bodies, so they decided to provide these decisions to the courts. And there were some radar assaults, and criminal cases were started, and there were arrests of officials, and it was done to remove competitors. And when these decisions were made through the courts, they had to do it through the courts, but some problems remained, and to some extent it remained in the constitution, but not in these relations. That's why in administrative justice, when we had reform and when these codes were discussed, the members of the working group tried to come out of this formula, but they were not able to do it because in Constitution we have a provision according to which the local government and state bodies, they had to address to court, and in order to avoid such addresses, we have to introduce changes to Constitution, and in Article 39 it is stated that only entities of governmental power can address courts in order to prohibit peaceful gatherings, and there are such provisions in Constitution, and these matters are reviewed by these courts, and it is difficult to overcome this, and we are provided with a lot of criticism, not only by Polish colleagues, but also from other colleagues from the European countries, from Germany and France, because they do not have this. Only a person can address to court, but we still have this provision on the entities. So also there are entities of governmental power also address to courts on the matters of foreign citizens if they are have some problems with law. So people, they there are some and all the cases concerning extradition from the territory of Ukraine and concerning the placement of the person to some facilities in order to identify the person. So these claims are sent by Border Guard Service and SBU. They send claims to Migration Service. Also can address these courts, can send these claims to courts. So we have these disputes. So also controlling bodies that implement the responsibilities, they also address to courts in order to carry out control and checks. So they do it through the court. So I believe that we will have the opportunity to discuss this topic later during our discussion. That's why I'm sorry. 1 minute. So when there is a criticism about our administrative structure, we see that constitutional provisions do not allow us to change in this respect like it is in other European states. That's why we have such a situation, and also statistical data. And I won't take much time. So High Administrative Court, during this 11 years and 10 months of its work, reviewed 600,000 cases, and I reviewed 8,000 cases myself. So that is so in 11 years, I reviewed 8,000 cases. So starting 2013, I, as a secretary of the Plenum and the deputy head of the court, they provided half cases other judges review. So other judges reviewed about 12,000 cases. So why we need these reforms and new forms of revision of cases and introduction of the new principles? This should be done in order to make our judiciary efficient and quick. Thank you.
Thank you.
This presentation and stressing the key problematic issues in the administrative judiciary in Ukraine. Now, when we have the broad view of the systems both in Poland and Ukraine, I think we can move to the very current subject of reforms. And now I would like to ask Mr. Roman Kuybida to tell us what is the background of the reform. I know you made part of the experts that created administrative judiciary in Ukraine, and how do you view the changes in the code itself, in the new bill, and more broadly in the context of the whole reform? Is there any chance that the changes will make Ukrainian administrative courts work more efficiently and be more citizen-friendly?
Good morning. Thank you very much for organizing such important and very actual event and for inviting me. I would like to start with some background remarks. 12 years ago, Code of Administrative Justice or Administrative Proceedings was adopted by the Parliament, and Ukraine started to create administrative courts. We had very high expectations from that because we think that finally Ukraine create a form of civic control over public administration, as mentioned Judge Przybysz. Unfortunately, courts was created from judges from commercial courts and general courts, and corruption and political dependence of such judges, mental political dependence of such judges became illness also of administrative courts, administrative justice system. A year ago, the Parliament passed amendments to the Constitution which started a complex reform, not only of administrative justice, but also of all judiciary system. One of the main aims of this reform was create really independent courts and create more simplified and more fair justice. Amendments to the or new version, new edition of Court of Administrative Proceedings or Administrative Justice has many positive moments, but I think has also some problems. For example, PROS, it's e-justice, electronic justice, when parties can apply to the court, can receive information from the court through internet, also can take a part in court hearings also through the internet. I think it's a very important reform in judiciary system. This reform establishing e-justice is not a part of reform only of administrative justice, but also of other kinds of court proceedings. Also establishing some new simplified proceedings, also a good part of this reform. I think such simplified proceedings can accelerate resolving of administrative cases. Also, a very important part of reform is creation three-instance system, court system, instead of four system, because now we have a four system, four-tier system, court system. It's on bottom level local courts, on the second level appeal courts, on the third level it's higher specialized courts, including a high administrative court, and on the top level high Supreme Court of Ukraine. And now we have Ukraine on the stage of reforming top level. We create one Supreme Court instead of three high specialized courts and Supreme Court of Ukraine. And for this system, we need to reform judicial proceedings, because we need to create a new cassation, new institute of cassation, because now we have two different proceedings between in high administrative court and also in Supreme court. Also, I think a good provisions in new draft is pretrial mediation. Yes, we have some discussion moments in this mediation, because judge during the mediation process can have confidential meetings with parties separately from each other, and I think it can be used for some corruption meetings. I think there are many another positive moments, but I also would like to set some problems. For example, court fee. I think when NGOs need to pay the same court fee like commercial organization, it is very big problem for such NGOs, for non-commercial organization, because now difficult for such organization, difficult to execute their activities, because some organizations try to protect their rights and rights of their members through courts, but now the court fee will increase, especially in top level of instances. Also, I cannot understand a new figure in administrative proceedings, so-called legal expert. I understand if legal expert, if courts invite legal experts for explain, for example, rules of foreign laws. But I don't understand why why judge, which is expert in the law, need to invite another legal expert to provide some aid in legal questions. Also, I would like to say about more general challenges to reform for reform of administrative judges. I think we have some bad signals that renewal of judicial corps, which was started and now in the process, can fail because, for example, many judges of high administrative courts applied for a post in new Supreme Court, and they are candidates, and at the same time they are judges in case where in another candidates try to challenge results of such competitions. And I think it's a big problem because it can be, I think it can be part of some political trade of posts in a new Supreme Court. Also, a second challenge is the situation when we have too much cases initiated by state bodies against private persons in administrative courts. So the aim of administrative justice to protect human rights, I think in such cases is not implemented. Third challenge is the situation when Ukraine has no general law on administrative procedure in administrative bodies. We have too many different proceedings which is regulated by the rules of administrative bodies. And yes, we have in our Code of Administrative Justice some principles of administrative procedure in administrative bodies as a criteria for administrative courts to evaluate administrative acts. For conclusion, I would like to say that we need to have more complex reform. I think we started a very complex reform when we tried to renew judicial corps and change the court system and also change and simplify some rulings of procedure, but I think that's very important to have more complex reform of administrative justice, which will cover also questions of administrative procedures in administrative bodies, and also which exclude cases against private persons from subject of administrative justice. Thank you.
Thank you very much. Now I would like to ask Mr. Viktor Korolenko, as the representative of the initiator of the bill, of the amendments to the Code of Administrative Justice, and not only to all the other codes. I wanted to ask you what are the main changes in the code, but already Mr. Kuybida mentioned a lot of them. So please, if you could address the problematic issues that Mr. Kuybida mentioned. And what do you think? Is there any possibility to improve the regulations so that they meet today's need of Ukrainian citizens even more?
Who should be answering?
You.
Okay. Well, if I have to start my speech by answering the questions of the previous speechmaker, okay. About the court fee. Of course, the increasing of the court fee can be considered as sort of the setback to the approach to the justice of any person. That's right. On the other hand, according to the European practice, judicial system in Europe is financed by more than 50% due to the income of the court fees. In our country, the share of that sort of financing of judicial system is very, very low. So about 1.5 years ago, there were amendments to the bill on court fee, increasing it rather seriously. On the other hand, that step let the judicial system get more financing, and it got be developing much faster than it has been before. However, I agree. This is a very sharp instrument, and increasing the fee, court fee, for higher stakes, irrelevantly to the increase of the level of living standards in Ukraine, can make some setbacks to approach the justice. In the bill of amending the procedural codes, on one hand, you may spot some minor increase of court fee, but I have to stress your attention that in average, we will not have that increase. What are the purpose of that slight increase? I'll explain right now. First is that if a person applies to court in electronic forms, the court fee shall be cut by a decreasing coefficient. This is the incentive for all litigants to apply to court in electronic form. The other leverage which has been affected by that slight increase of court fee is that if parties of the judicial of the law dispute come to the peaceful agreement, 50% of the court fee paid by the plaintiff at the start of the case is to be reimbursed. This is a very high leverage to motivate parties to, especially the plaintiff, to sit round table and make peaceful agreement on the grounds of the dispute. Plus, the slight increase of the court fee should support establishing the e-court in Ukraine with that seriously less costs on paperwork, on the transferring cases between different courts without using the modern IT technologies. These costs are rather high, and we expect that with establishing an e-court, we'll get a much more simplified approach to justice, to more rational costs to support the justice. So all society and the state shall have direct benefits after establishing e-courts. So e-courts also needs huge finance resources. One of that resources also is court fee incomes. So that's why the court fee has been slightly increased. The other question that previous speech makers made is that what is the reason to set up such a player in a court procedure as a legal expert? Legal expert is a widely used institution in European jurisdictions. It's not an expert in its initial meaning. The statements of legal experts is not a source of proofs. The legal expert can be retained by any of the parties in two particular situations. One is that the meaning of foreign law is to be defined correctly if the dispute relates to the norms of international law or foreign law. This is one issue. The other issue is that when you need to use the analogous of law, in such cases, it would be quite desirable that someone with academic research background could make a speech for court hearing of the case. So both the court and the parties would benefit with the statements of the legal expert. At the same time, I will repeat, the statements of the legal expert is not a source of evidence. And I heard that the courts shall have to retain the legal expert while considering the case. It's not true. The draft bills do not have such prescription. Only parties can render legal expert in certain cases defined by law. As for the e-court, I told that e-court is to be a reality. E-court shall mean that both in paper form and electronic form, any person can apply to court. It's not a transitional period. It's going to be a long time procedure. So there should not be any discrimination with regard to a person, meaning the plaintiff, has knowledge of IT technologies and IT hardware or not. So we expect that the e-court shall simplify approach to justice. And now, if you let, I will start my short brief on the main novels or in administrative procedure code. A working group set up by the by the Council on Judicial Reform has started its work on drafting amendments to the administrative dispute codes as well as the other trial procedure codes, following the strategy of judicial reform set up by the by decree of the president in 2015. Roughly, there were two main directions for developing the amendments. One is that we'll have to set up new trial procedure according to the international standards in judiciary, and using the best practice of our European partners. The other issue was to use the experience of applying the current administrative procedure codes. First point, after researching international foreign administrative procedure codes, was that we are going in time with our European partners. The present administrative procedure codes basically is according to that practice that European countries have. Though there are certain our domestic diseases that we have, as well as in administrative trials. These are that the principle of official considering the case is manipulated, and when a person applied to court to protect its rights, let's say in a tax dispute, the court starts tax investigation against that applicant. While considering the disputed act of the state power body, new evidences which were not taken in consideration by the state body can be used to prove that this challenged act is legal. It means that a state body can make an act without any evidence at all, without any grounds at all, if we let that state power body use the evidences other one than those that should have been applied to while making its act. We have very, very long terms of considering the case. Regardless, the case is simple or complicated. And as any other court jurisdiction, administrative jurisdiction operates in four-level court system. These problems and some others has led us to finding solutions, at least to main problems. So, in new administrative procedure codes, there is a certain touch to definition of administrative dispute, and there's it emphasizes that the jurisdiction is to be defined according to the nature of the dispute, not according to the subjects of the disputes. The bill is proposing to use the derivative claims, which is related to the initial claims. It should serve the more effective protection of rights of the plaintiff, since if in current practice in courts, we can see that you may challenge some state power acts, but after that you will have to go to the commercial or general courts to challenge the agreements or another private acts relating to that initial state power acts, which this situation means huge and long court battles for a plaintiff. About e-courts is said enough. About the way instruments to prove the to defend the rights of plaintiff and defendant. Or the bill is proposing to set up a new source of evidence as electronic evidence. These are files or similar nature components. These are websites, pages, and similar materials. A new approach to submitting the expert reports. Presently, expert report can be a source of evidence if the expertise is set up by court. The bill is proposing to render rights to any person to apply to a person with certain knowledge to have its report, and the court should have take this report as an evidence. And the court is only have the right to set up the expertise while considering the case if there are no such reports from the parties in a case, or if there are contradictions between the expert reports provided by the parties, and the court has come to the point that contradictions cannot be settled within that reports. So we propose to have the competition between experts and courts instead of having monopoly on knowledge, which is sometimes necessary while evaluating the proofs. Rights and obligations of the parties. This aspect is related to a new approach to the stages in considering the case, because at certain stages a party shall have certain rights, and so there are basically two different approaches to the case management: simplified procedure for smaller claims, and general procedure. Within simplified procedure, the case shall be considered within 60 days. Maximum 30 days for preparing the case and 30 days for considering the case. General procedure means 90 days, maximum 60 days for preparing the case, and maximum 30 days for considering on the merits of claims. The bill shall have points on protection, the trial against the abuse of procedural rights that sometimes happen. Presently, we have almost everyday examples when plaintiff, or especially defendant or his lawyers, tries to make a mess out of the case, leading to endless hearings. So we propose to have clear instruments for court to stop that abuse of procedural rights. According to amendments to the Constitution made last year and its transitional points, Starting from 2020, state bodies shall have to be represented in courts by lawyers, meaning the members of the bars. We expect that it shall lead to a more professional approach to protecting state powers bodies in court, to trust to using the procedural rights for the matters, for the aims these rights are granted to a person, since presently even representatives of the state, especially I have lots of examples in tax disputes, they abuse procedural rights, manipulating with evidences, leading to prolonging the terms of hearing and many other attempts to protect by this illegal way its rights. Also, effective reimbursement of court costs. We propose certain instruments and criteria to define that some costs of the parties to be reimbursed, but with certain limits. The cost of the state power body could be reimbursed only for the purposes of expertise and calling for witnesses. The costs of the legal bodies of physical persons could be reimbursed without limits of the nature of that cost. This should lead to retaining professional lawyers to represent persons in administrative disputes. This should lead to careful decision-making for the state power bodies, so they should be aware that in case they make some unfounded decisions, that decisions could be challenged in court, and after finishing the trial, the representative of the state body power shall bring back to office loan bills to be paid from the state budget to reimburse the costs of the other party. In administrative procedure, we proposed the procedure of pre-trial dispute settlement. The model is borrowed from the legislation of Canada. We decided to use this procedure because of the good results of pilot cases that were started according to the Canadian project performed here in Ukraine 2 years ago. I have to say also about the pilot case model. That procedure is also implemented in the bill. We expect that it shall have to obvious decrease of number of cases. The model in main features is repeating the model which is well performed in European courts on human rights. There are certain filters for following in the cases for cassation review, so that if there are no founded statements on misfollowing the practice of the higher court. In that case, the cassation application can be turned out without opening the case. And also there are certain other filters leading to the position imposed by international standards on judiciary that cassation is the stage where the serious matters or law disputes should be considered, not the smaller cases where the core reason for the dispute is the facts. And of course, the amendments envisages or implements the amendments to the Constitution, amendments which are taking place last year, changing our court system from 4-level to a 3-level system. Also, there's one more change or amendments to the law, which is which applies not to the Administrative Procedure Code as it is. This is minor changes to the bill to the law on the public service, envisaging that if a state employee in its decision does not follow the legal position of the higher court, this could be a ground for disciplinary proceeding against that state employee. We expect that should also make that state employees in powers scrutinize his decision according to the law and law practice of the higher court.
Thank you very much. We have to move forward to the other speakers.
Yeah,
because we don't have much time.
Someone else's time, but in fact, the number of amendments are very long.
Yeah, thank you very much for this like full of details presentation of the project presented in the Rada by the President of Ukraine, and for addressing the issues mentioned by the previous speaker. Now I would like to turn to our Polish expert present today with us. I would like to ask Professor Marek Wierzbowski, basing on your great experience as a legal practitioner, what are strong and weak points of the administrative court procedure in Poland, in the world, that you could share with us? What regulations could you suggest to include into the new law in Ukraine, maybe, or the other way? What regulations you heard about today could we adopt in Poland?
Thank you very much. I feel very honored to be invited to speak in such a company. It's a great pleasure and honor for me. Generally, international speeches or speeches in such a company should start with a joke, but I'm afraid a little bit of a joke.
Please go on. Go.
Following the corruption to bring small gifts. These are books made, published in Polish, virtually made in our Department of Administrative Law. The first is commentary to the proceedings before administrative courts. It's done by a number of judges and professors. There are two editors. The first one is the president of our Supreme Administrative Court. The second one is me. Can I pass it to you? Can I make another gift? That's our 18th edition of a handbook on administrative law. Can I pass it to you? Always you can, if you don't like, because it's in Polish, always you can pass it to the university library. The university library is going to accept everything which is published. And the third is a book which was published simultaneously in French, German, Spanish, Italian, and Romanian. It's a model code of administrative proceedings for European Union. The English is just in print, the English version, and also there is web page. It's an attempt to unify the law within not only European Union, but generally the entire Europe, and that's for you. You can easily find this renewal, which means research network on the European Union administrative law. It was done by the group mostly of university professors, few judges. It's well known. There are several attempts in Europe to unify the system of administrative procedure, administrative justice. Currently, I am, besides this one, in two such projects. One is Administrative University in Speyer, and they assume that system can be unified by the decisions made by European Court of Human Rights and resolutions made by Council of Europe. The second one is a project within European Union started by two Italian professors, and they assume that we have different systems in different countries of Europe. But the results of the case are the same. So they start with giving examples of the cases and asking people from different countries what would be the decision on such cases. And they find that in spite of different history, because we have countries of common law tradition and so on, and the result will be the same. So there are strong attempts to unify, to get some kind of unification. Tradition of European continent, which was spread also to other countries, like former Russian Empire, is the division of the law into two branches. One is public law, which relates to government, and second is private law, which relates to private parties. That's old Roman tradition going to Byzantine empire, and this division is still vivid. If you speak to professor from Germany, in first few phrases he will say, I'm professor of public law, I'm not going to address the problem because your problem is of private law. Or would say, I'm professor of private law and I'm not going to address the problem of public law. So it's still alive, and as a result, we have separate, most of the countries, European countries, I mean countries of European continent, separate courts or institutions like French Conseil d'État for public law, for administrative law, and separate for common courts, which is civil law. But the borderline is drawn between public law and private law in different places. In different places in Germany, and Germany proved to be quite influential to the countries east of Germany, ending with Japan. And different tradition is in French. In French is more even complex. Some time ago they had problems with the accidents done by government cars, if they should belong to. Now all of them belong to civil law. Poland has moved very far in drawing the border. So virtually, if we enter contract with the government, we assume that this is private law, it's civil code. If we have claim against government to pay damages, we assume that this is civil law. We went much further than Germany or France in moving the border between public law and civil law. We do not have in Poland institution of public contracts in reality. Public procurement, I just came from the conference, is considered to be, except supervision, to great extent private law. As a result of that, courts, administrative courts in Poland only handle appeals against administrative decisions. They do not handle the disputes between government and individuals, disputes different than appeal to the decision. The courts are currently, I would say, always there are new changes. The problem is that virtually we have appeal within administration, and then we have two levels of administrative courts. So, in fact, the ordinary case can go through 4 instances. First, second instance in public administration, then 2 instances of administrative court. Then when it gets to the top, at the top, the Supreme Court would decide, okay, judge, you should decide this case again, so it will send it back. Then the judge at the lower level will send to the administrative authority. You have to decide it again, in this case. So the case may last 5 years, 10 years, or even more, and it's one of the problems. One of the problems is that administrative cases are very difficult because judge is a lawyer, but if you handle telecommunication case, for example, or case concerning financial markets, judge is not expert. Law became so complex that he has problems to handle it, how to write the decision. So the best way for the judge, please excuse me, would be to send it back. Say, okay, there was procedural error, decide this case again, and then the judge is free to write reasons. So for that purpose, I understand your idea about legal expert, that sometimes expert may be needed to explain to the court how particular law concerning some technical aspects, like for example construction law or financial markets, how this should be decided. On the other hand, there is a danger that in such situation, legal expert will turn to be really judge, because for judge would be the most convenient way to cut off parts of the expert's statement and put it into decision. Looking on the reform you plan, of course, it goes into a little bit different direction because you start to make, you have just one structure with Supreme Court at the top. But frankly speaking, I would be very far to be brave enough to evaluate it. But what you have said, I like it. With the idea to simplify the structure, to simplify the cases and so on, because many cases are virtually the same, and it's a huge problem for every administrative court in Europe that they are flooded with a number of cases which are simple, which are very similar. Probably I should talk more about practice, but I'm put in a strange situation because I'm both university professor and private lawyer. However, my company is composed of distinguished judge who already spoke, and a private lawyer from a huge international firm, Dentons. So to avoid situation that I will consume what my friend has to say, I will finish in this moment. And if I may turn it to Professor Jabłoński.
Of course, thank you very much. We'll save this time for discussion and then to questions to Professor. So now let's move to Mr. Mykhailo Jabłoński. I would like to ask you to somehow conclude our discussion, because I know that you studied the changes made to the code in Ukraine, and as practitioner as well, as Professor Wierzbowski mentioned. Do you think that they are heading in the right direction? And taking into account the significant differences in the two systems, in the Polish and Ukrainian one, after what you heard in the discussion and judging on your experience, do you think the reform will make the Ukrainian administrative courts work better?
Thank you very much. I'm also honored to be here. I'm glad to be on this meeting with my colleagues and other experts. Starting my speech, I'm of course on the difficult position because many aspects of the reform and many aspects of the current administrative court procedure in Ukraine was presented by my colleagues and other speakers before me. So I'd like to summarize some ideas here and try to make comments on this on some of aspects of this reform which you try to introduce here in Ukraine. Of course, it is difficult for the Polish lawyer to evaluate the procedure in the foreign country, which is for sure different and than court procedure in Poland. I can see such differences here. So I think that my comments, you should treat my comments as only suggestions. But I think that always the Ukrainian lawmakers should try to go by their own way, because you see, we've got the administrative court system nearly since 40 years in Poland. We've got, of course, we had some reforms of this system through many years. So of course, it is not the same administrative court system as in 80s of the 20th century, when the administrative court system was introduced in Poland after many years when the administrative courts did not exist in our court system. So of course I remember that I was on the International Administrative Law Conference in Lviv. I think it was 3 years ago or 4 years ago, and I listened to speeches also of administrative law professors from Ukrainian universities, and they presented some issues which they try to resolve in connection to the administrative court proceedings in Ukraine. And I got the impression that these issues are issues which we had also in Poland before, and we just resolved them. But after I was thinking about it, I led to conclusion that you cannot simply take our experience from Poland and implement it in Ukraine. You have to try to develop your own way, because you've got the different administrative court system than Polish. For example, our administrative courts do not conduct evidentiary proceedings. There are not evidences in the administrative court. It is restricted only to the documents. Sometimes documents could be evidences in the administrative court, but in a very limited scope. We don't have, for example, witnesses in the administrative court. I heard that in your administrative court proceedings, there are witnesses in the proceedings before the administrative court. So it's the, I think, huge difference. We've got the administrative court proceedings based on the criterion of legality. The administrative court examines whether the decision of the public authority was issued legally. Of course, I know that you have got the same criterion in the Ukraine, but as I learned, the scope of this criterion is somehow broader, because you've got also the, for example, the issues of abuse of powers, of the impartiality, of the good faith of the public authority, good reasoning of the decision. So, of course, we can say that we've got all these issues mixed in the criterion of legality in Poland, but it's not so easy to compare it. So I think that definitely you've got broader scope of the examination of the acts and omissions of the public authorities than in Poland. And this is why I think you've got, for example, the evidentiary proceedings in the administrative court, because you have to establish, the administrative courts should have to establish more circumstances than Polish administrative court, which does examine only the legality. So if the Polish administrative court sees that the public authority conducted the evidentiary proceedings illegally, some standards, legal standards of the evidentiary proceedings were not fulfilled by the public authority, then the case is sent back to the public authority, but the court does not conduct any evidentiary proceedings, so the court does not replace the public authority in establishing circumstances of the case. The Polish administrative court is competent only to examine whether the rules of the proceedings were fulfilled or not. So I think that this is the main difference between our systems of the administrative courts, and of course the other difference is the difference that Professor Wierzbowski mentioned, that regards the scope of jurisdiction of the administrative court, because as Professor Wierzbowski said, our administrative courts do not control public contracts, for example. So it is the so I know that if the administrative court in Ukraine controls also public contract, then the evidentiary proceedings is also required, because it's the only manner to verify the case, to verify the contract and obligation of the parties which are implied from the contract, and also whether these obligations were fulfilled by or good performed by the parties. In Poland, such cases are are dealt by the civil courts, so in the very different proceedings. Okay, so I think that people go to administrative court. Of course, they go to win, but it's a very plain understanding of the role of administrative courts. People go to the court for to receive justice, in the most effective manner. This is my understanding of the administrative judiciary. What I understand here in this expression, people feel that they are treated by the administrative authority unfairly, or the administrative authority issued the act which, in view of the claimant, is contrary to the law. So they go to the court, and they just need to have a resolution of the case as soon as possible, because if not, the proceedings last many years, and then people just don't understand why they are in such a position. So they just avoid judiciary. They avoid to go to the court because they feel that they won't receive justice in effectively manner. So they try other possibilities to gain their goals in the legal system. I think that our experience from Poland is slightly the same as yours in this respect of effectiveness of the administrative courts, because in our judiciary system also cases sometimes last many years, 5, 6. So for example, my colleague, another advocate, showed me case files where it was some case of restitution claims to the property which was expropriated during the communist time, and he showed it to me and showed me the last document in these files was the decision from the 1998, something like that. And he asked me, listen, do you think that this case ended and there won't be any problems with the property? I said to him, you know, I don't know, because I saw cases which last, for example, 10 or 15 years, so it's possible that the case is still pending somewhere in the administrative court or the public authority. And so, of course, this is a problem. And Professor Wierzbowski said that sometimes the Supreme Administrative Court passes the case back to the first instance court. Then the first instance court passes into the first instance authority, because we've got two instances of administrative proceedings before the public authorities. And the case sometimes is just moving down and moving to the top. So it's a huge problem, because, for example, when I talk with foreign clients, for example, the client from Japan, and he's just confused. He don't understand it. Why it lasts so long? Why why the case is just passed from one instance to other instance? It's really confusing for the people who are not lawyers, or who are not lawyers specializing in Polish law, because also lawyers from other jurisdictions don't understand it. So it's also our problem. And the other issue is that the administrative court, and I believe that it is somehow also existing in your judiciary system, that for example, the Supreme Administrative Court decides on the case, and the court accepts the cassation complaint to the Supreme Administrative Court and passes the case to the first instance, for example, and the client asks me, listen, did I win or not? And I don't know what to say, because I can say to him, of course, technically you win, because your cassation complaint was accepted by the Supreme Administrative Court. But we will see whether the, for example, first instance court or the public authority will follow the instructions which were made in the judgment of the Supreme Administrative Court. So for me, the ideal administrative court proceedings and administrative proceedings in general is such a proceedings where the case is resolved in the reasonable time. So the party and the judgments of the courts are really final. So the party is not forced to just move from one instance to a second instance and back and so on, because it's really confusing. And speaking about your reforms, I think that most of them are really reasonable, because these attempts to simplify the proceedings are really worth attention. For example, you are planning to introduce the simplified procedure in the administrative court. We've got also simplified procedure in Poland, but I think that there is one huge difference between these legal systems, because in our judiciary, the simplified procedure, as the judge Przybysz said, is examined. The case is examined in the simplified procedure on the secret hearing without parties. There are not parties. The parties are not appeared on the session. So, what for? Because then it is faster. The cases are examined faster than on open sessions. So this is the main reason. So I think that if you try to simplify the procedure and resolve some kind of cases which are, for example, of less importance or just simple cases, you can just take into consideration introducing the secret hearings, for example, which are the type of sessions which are tested in our administrative court procedure. I understand this attempt to divide cases into typical these model cases or precedent cases and cases of less importance. And I understand that that judgments in these model cases would be somehow precedent for the other typical cases, and then the courts will be bound by the legal view presented in the model case. Of course, we've got something similar, which is called resolutions of the Supreme Administrative Court. But my doubt is that whether there will be any, and maybe it is a question to our Ukrainian colleagues, whether there will be possible to derogate from the legal view of the Supreme Court in this model case. For example, I believe that sometimes the party which is claiming that act of the administrative authority is illegal, in typical case which have the precedent previously decided by the Supreme Court, claims that the party just needs resolution of his or her case and want not to be bound by any legal view of the judges which were not involved in this case. So because I believe that any other party wouldn't have a chance to review, for example, the judgment in the model case or challenge it, because so there will be bound by the legal view which they were not able to challenge in any way. So it's I think it could be a problem also for your civic rights of the claimants. In our legal system, resolutions of the administrative court are binding for the administrative courts, but there is a possibility to move the case in other way. Of course, in such a case, the jury panel is required to ask the Supreme Administrative Court again for the resolution, for the new resolution. But it is possible. So maybe it is also a thing which you should take into consideration. The matter of this legal expert. We have not legal experts in our administrative court procedure. Of course, it does not mean that such experts don't exist, because of course the parties are submitting legal opinions to the court. It is out of the procedure, but they can do, and it's just a part of the argumentation of the party, and it is not any specific evidence for the court. It is not evidence at all. It's just a part of argumentation of the party, and I think it's an interesting idea here, but I got doubts because usually there is a principle that jura novit curia, and the courts should know the law and should know how to interpret the law. And I understand that this concept is rather regards for example, matters of international law or something like that, but still it could be controversial. My suggestion is that it could be better than if the court would be competent to get such a legal opinion from the legal expert than the parties, because it is always the risk that the legal opinion that is submitted by the parties is written in favor to this party. So this is the matter of the legal opinions that are prepared on by legal experts working for one of the parties. So I think it could be a problem. So maybe you could take into consideration to move this competence to get legal opinions from the parties to the court, because I understood that this is the competence of
excuse me, just we have very little time left for discussion, so maybe let's just please conclude, okay?
Okay.
And then we turn to our audience, okay? Thank you very much, Dr. Wierzbowski. We have still some time, very little, for questions from the audience, so maybe just one or two brief questions to our experts, and then maybe we will move behind the scenes and we'll discuss the legal issues there. Please, are there any questions? Is there a microphone?
Я буду до українських експертів, а якщо англійською?
This is to Ukrainian experts. A lot has been mentioned. Thank you for very detailed discussion on courts. What is the main reason why the cases are delayed? I would like to ask Viktor about that. I can express the opinion as a person who attends courts very often, but I believe that the answer could be provided more objectively by the representatives of the judges. But I believe there are several reasons why the cases are delayed. The number of in cases when the plaintiff understands the weakness of the position, tries to delay, and for that they use different methods, appeal against some intermediary rulings, so that the case is directed to the court of higher instance instead of considering it on merits, then involving some third party when there's no reason for that. Then the representative of the party does not come to the court, and he informs that he or she participates in a more important case. Then when it goes, switches to written proceedings, and in written proceedings it takes months, even though the law sets the limits, but still this happens in practice. Then the court appoints the expert review. Even when such expert review is not needed, the case is suspended, then the case is sent to some expert body and then returns in half a year. Well, objectively, if we group together these cases and say why this happens, first of all, it's it's when the courts and parties abuse of their rights. Then there's imperfect communication. For example, the party was not informed about the time and place of considering the case, so the case is transferred to the cassation instance, and it takes long time. Of course, there might be the case when the judges are overburdened, and that is objectively the situation. So the reasons are in organizational aspect. So these are the main aspects. There could be more, of course. How long will it take to implement the court reform? Maybe it will last for many years, and Ukrainians will never start trusting the courts. As to the judicial reform, the priorities of the reform have been set. The actions are made, three main components that I've mentioned today: institutional reform, personnel reform, and reform of the legislation. All that is almost finished, almost completed, but I don't want to say that this will be the end. Definitely we will be improving all these things even more. If you look at whether there are permanent amendments in the other countries, I can tell you that this is the permanent evolutionary process. Like for 25 years, there has been practically no system reforms in Ukraine.
And now we have to implement reforms in a short time to bring it to the world standards. It is an evolutionary process. We should work on it on a systemic way. Couldn't hear the question. So you mean legal aspects that are identified by law? No, you've mentioned legal experts, so I asked about them. If we are speaking about the changes, the legal aspect, the expert on legal matters, so this expert is not a participant. The only thing he can do in the process is to present a speech concerning the issues in his competence, and there are no special proceedings. He has limited responsibilities, and that's why there is. Good afternoon. Thank you for this wonderful discussion. I have a question to our Polish colleagues. You've mentioned that not all experience, even positive experience that exists in Polish administrative justice, not all of it should be implemented in Ukraine. So you know about procedural legislation, the draft laws. Have you seen some aspects that so the implementation of which would not benefit to Ukraine?
I'll try to answer it. I understand that you meant that these parts of reform which are planned to introduce, but some of them perhaps are not beneficiary for your country. Okay, so I think that it is not the matter whether such reforms would be beneficial for Ukraine because, as I stated before, it's very difficult to evaluate it from the position of Polish lawyer trained in a Polish legal system and participating in the proceedings before Polish administrative court. But I think that the problem is different. I think that some of these reforms would not work because for example, if you mention in the bill that the maximum period of the case would be 120 days, and on the other hand, as I learned, your administrative courts conduct full evidentiary proceedings. I believe that it is rather impossible to have the case resolved in such a short period. So I believe it could be just a fiction that this period would be fulfilled. But I don't know. Maybe your courts are much more efficient than Polish courts, and the case would be resolved in such short period. But basing on experiences from Polish administrative court, we've got the administrative court which do not conduct evidentiary proceedings. So usually there are some exceptions, but usually the case is resolved on one hearing. But we have to wait a month from this on this hearing to participate in this hearing. So, for example, if we file a appeal against the administrative decision to the administrative court, then it is usually half a year of waiting to the hearing before the court. And again, I underline that we've got no evidentiary proceedings. The court only controls the legality of the decision and does not conduct any evidences. So, basing of this experience, I don't believe that you will achieve this goal in your administrative court system. So, I think it is not a matter. Of course, we can discuss many other things here, but I think that it is the most explanatory part of your reform to show this paradox, that perhaps not all of your goals will be achieved by means of this reform.
Good afternoon, the Institute of Legislation of Verkhovna Rada of Ukraine. I have question to our Polish colleagues, to Professor Przybysz in particular. If we take as an example Ukraine, according to the administrative code of Ukraine, the jurisdiction of administrative courts covers the cases of public disputes when the subjects of public bodies submit their claims. There is an article on prohibition of peaceful gatherings. That's the article in the code. How, according to Polish legislation, this issue has been resolved? Can the subjects of law, can the subjects of governmental bodies be the subjects who submit their claims?
We have completely different regulations because the public gatherings are organized on a principle that the organizer just goes to the community and informs the community that they are going to make a public gathering. That's all. And then people can gather according to the law. And there is a possibility to make a decision prohibiting public gathering. So then the organizer can go to the court and might say that this decision breaks the law. It's quite a simple procedure, but I don't know exactly because I deal with tax law cases, so I cannot say anything more.
Thank you very much. Unfortunately, I think we don't have much more time for any questions. So I would like to thank all our guests, all our panelists, and the audience for being here. I hope that this discussion brought some new ideas on the subject of reform of administrative judiciary in Ukraine, led to some new conclusions. And I think we still will have some time to discuss the issues that are interesting for you in private after the session is ended. So once again, on behalf of the Center for Promotion of Polish Legal Research, I would like to thank you all. I would like to thank the Ukrainian Crisis Media Center for hosting us, and please follow our activities. Thank you very much.